I'd also add that I am happy with our new commissioner.
Excellent.
I don't know, is that poisoning the well or this?
Yeah, right. Off topic, I'm
Yeah,
sorry.
the opposite.
Yeah. So,
What else is he going to say at this point?
yeah.
Perfectly honest.
It is
Okay.
perfectly honest, and I could go on, but I shall not.
Okay, we got other fish to fry
Yes.
here today.
So I think that we're here because there have been some concerns about the current enforcement process of the Public Service Board. And I could talk about the difficulties we've encountered. I can understand the unhappiness of people who have filed complaints and then seen the process kind of go on and on and on. Some violations are going to be major and are going to, in essence, require that much process. But there are certainly category violations that do not warrant that, and for which there ought to be a more swift and sure and predictable remedy. And I think that's what we're looking for here. By way of context, when I don't want to go with the war stories, but when I started doing this, we regulated a couple of dozen electric utilities and a handful of independent power generators. We rate regulated the utilities, and you've got a lot more cooperation and responsiveness when you, as a former chairman would say, when you had them by the rates. You know, their hearts and minds tended to follow. And now we have thousands of power generators out there and thousands of certificates of public good, all with conditions. So we need to retool. We need to transform the process and make it adapt to the new situation that we find ourselves in. The department is happy to take on the additional responsibility of trying to implement a more streamlined process. There are, I will confess that we were tempted by the notion of booting it all over to A&R. There is an appeal there because they have an existing enforcement apparatus, which we do not really have a counterpart for. It will take some gearing up by the department. It will take some reclassifying of positions. We're not asking for more positions. We're not asking for more money, but it will take some retooling within the department to make this happen. We're willing to take that on. And I had some comments and markup on a prior draft, which are now not all that helpful, but I can make a few observations here that I hope will be helpful.
Is this draft workable for you? 2.2?
I believe that it is. I think there are some modifications that I would propose to it.
Okay. And
And we're talking specifically of the
opportunity to get
enforcement.
those back to us before we vote anything out here.
I'm sorry, ma'am?
We won't vote anything out
Oh.
until you have an opportunity to.
I would very much
Yeah.
appreciate an opportunity to look more closely at this and propose some different language. I just identify a couple of concerns.
And now we are looking at the enforcement only, right?
Yes, sir.
Are we going to look at the whole bill?
At this point, I'm focusing on the enforcement section of the bill. One of the difficulties of trying to make this very streamlined is that there will be, this is different from the situation that A&R faces in that instead of going to Superior Court, or the Environmental Division of Superior Court with an appeal, or that could weigh in on these matters, the Public Service Board also has an interest, and they are not simply a court, but they also have expertise and are insulated from political pressures and so forth, and public pressure for a reason. And they are also more interested than your typical court in how these matters work out, whether these statutes are being executed in an appropriate manner. And I think that that's one of the things you'll probably hear from the people here from the Public Service Board, is that one thing that seems to be lacking from this is a sign-off from the board or an approval from the board. That's not, I think that's not necessarily fatal. The difficulty comes in classifying violations. Right now, this has a maximum penalty of $3,000. I would recommend increasing that. My sort of off-the-hip recommendation would be to at least $5,000. One thing we don't want is a penalty that can simply be absorbed as a cost of doing business. The question is, what violations will fall into that, I'll call it a minor category, and which violations are in a major category where we really ought to be following the existing procedure under Section 30, which means going to the board, asking for a hearing, and having the full contested process. There could be disagreements about that. Under this draft, we copy the board with our notice of violation, but at that point, they don't have any more information than really is in the notice, and they're faced with preclusion. I mean, not being unable to do anything further about that violation, should their judgment be different. I think that's a concern that you will hear. And I think it has some validity.
Can I ask a question on that? So is the hearing to the board de novo from the violation?
Well, under this, there would not have been a hearing prior to that. As I understand the way this version is structured, the department could issue a civil citation, and a respondent could choose to contest it or not. And if they didn't, they would simply pay the penalty, and you're all done. They're all done with that violation.
There's an investigation and an administrative penalty, but is there any kind of presumption or record built up in getting there that the board has to give some consideration to in the case where they just start from scratch?
Under the scenario I described, of just the civil citation, if the person agreed to pay it, then the board would not be involved at all.
I know, but let's
Oh,
just
okay.
appeal it.
I'm sorry. Then the board would hear it right from scratch. There would not be any sort of record below, if you will. There would not have been a hearing. There would have been an investigation by the department. We need to put boots on the ground and have people go out and look at things, and we would have reached our conclusions based on that.
So reinvestigate, basically, right? Is that what?
Well, you have a full hearing, I don't know,
You'd have-
investigation they do, it's up to the lawyers to bring the evidence. So, just going back to the finances, I appreciate you saying you can do it within your budget, and we, as a policymaker here, I wonder why, if we're alleviating some functions of the public service board that they're doing right now, why aren't we taking some of their resources and moving to yours instead of diluting your department?
Senator, the resources that I have in mind in particular are investigative, are people to go out in the field. At this point, the department does not have, I take that back, on the gas pipeline, we do have an inspector who goes out in the field. Other than that, we don't have that staff now, but we would. The board would not have that staff. If
Oh,
they-
yeah, no,
Sorry.
I'm sorry if I got you focused on individual bodies, I'm talking about money. So there's a certain amount of these complaints that come through the board that they have to spend resources on to figure out what to do with it, that they're going to be alleviated with this streamlined approach. So theoretically, their administrative costs should go down somewhat, and yours will go up.
Senator, I think the premise of the question is not exactly right. At this point, the board would look to the department for the investigation and have the department present the case in front of it regarding violation.
When it comes to a formal board hearing, I heard you mention lawyers, and you said that would present their case. And the board doesn't have an investigator, and I guess other than the pipeline, which has turned up to be major, you don't have an investigative staff, which was the origin of saying, well, why don't you just turn it over to A&R, because they do. I assume when you get to the board that it would be the lawyer's job to go out and take the picture of the 3-foot hedge that's supposed to be 10 feet and present
The
it
lawyer
as,
will hire somebody.
yeah,
This
the
is-
lawyer will hire somebody.
We're,
His intern will go, or, yeah, but, it's a whole different, it's a whole different, we're trying to make this simpler and get away from the court, which, in the case of a 3-foot hedge that was supposed to be 10 feet, is probably relatively simple to look at and say, yeah, then you can argue how long it's gonna take to grow to be 10 feet tall. Has the department talked about having A&R be their investigative arm? Is that,
we have not had those specific discussions with A&R, but we are having this conversation internally now under the current procedure now, because right now, we receive complaints and we investigate violations. What it has been to this point is essentially a desktop. What can you find out from it? If a neighbor is complaining, you say, can you take some pictures and send them to me? If we've had an anonymous complaint, and what we did was, the facility in question happened to be, we knew it was right next to the town office in whatever town it was, we called up the town clerk, could you please look out the window? Tell me, is there a hedge along there? So, but that's clearly not sufficient to the need. And so we have already been having this discussion about how do we get people out in the field to do actual investigation.
and I think one of the complaints I heard from a member of the public was, they called up and said, can you take pictures?
It's not
I
satisfactory,
don't think
I
people
agree.
understand how really short-staffed we are. But that, if I'm paying taxes and I call to file a complaint, I can see where I might be a little put off and say, well, can you go take a picture and send it in? It
Mhm.
doesn't
I-
sound like you're really concerned.
That's not our preferred
I know.
option, yes.
So, okay, but this proposal would allow you to do the MOU, so it gives you the flexibility to move forward there.
If, we have that ability now to simply
Okay.
reach a settlement. At this point, a settlement would be, under most circumstances, if a complaint had been filed and we reached a settlement, we would file it with the Public Service Board for their approval. And particularly if it affected any change to the existing certificate of public good. You said, oh, well, you tried to put plants there, but it's solid rock, and you couldn't. If we want to change something that's in the certificate of public good, that has to go to the board, absolutely, yes.
I put them in and they died 3 times because this town dumps salt,
Right, whatever it is.
whatever, all right.
But as I say, we haven't had this need to have field investigators before, but now that there are generators in every neighborhood in the state, we need to
Yeah,
have that.
your landscape has changed.
Yes. Beyond that, I don't think you can really create a process consistent with due process that would tell people, no, you can't get a hearing, no matter what you do, even if it's a relatively minor violation. There has to be an avenue for people to contest the existence, contest the proposed penalty, and so forth. And the Public Service Board is a rather judicial process that citizens often do not find user-friendly. I totally understand that. But again, consistent with due process, you have to give people an option for a hearing if they want to contest the matter.
So that's on page 2, number A, 2A.
Yes.
Okay.
I think I would really very much appreciate the opportunity to look at this draft to it.
Does it relate to S.52 that was entered? Any other specific concerns or questions?
On the enforcement,
No, no, on the, that's what you were here for, all of S.52, correct?
that was not my understanding.
Okay.
I'm sorry.
What was your understanding, just so
That
that?
I was talking about the
Just the
enforcement.
enforcement. Okay, that's
Correct.
fine.
So we'll let you,
That's fine.
have time to read that over and get back to us.
That would be much appreciated.
So, I understand we moved away from the A&R thing, which I agree with, but it seems like we have a template within that A&R for like people appeal violations there, the agency looks at it, issues fines, you don't like it, go to de novo hearing, environmental division. Is there anything really different here that we can't just take that template that they use and apply to you and the Public Service Board? Maybe we're doing that.
There's, I think to some extent you are, and I think it's appropriate. I think we need to do it thoughtfully. There are differences. I'm not sure that, I think you'll be hearing from A&R. There are differences in the area, in their areas of expertise.
Sure.
Although that might be curable. And
I'm just
again,
thinking more of the legal process, because I'm worried about just make sure we have all the process. And I'm sure that they're a mature system already, so if we can just take their model and file might work.
yes, Senator, I think that there's a lot of value in that. Certainly, if we are given this authority, we will be looking a lot at A&R to learn things about how they do it. I think the difference that comes to mind is the tribunal that is sort of overseeing the entire process, or is the next step in the process. I don't think the environmental court has the same kind of interest that the board does in the, how penalties are dealt with, how these permit violations are treated. The board does have subject matter expertise here and is involved in the substance of these matters to a degree that I don't think the environmental court is. So the environmental court may not care if A&R, does a civil citation and accepts a $2,000 penalty, and that's fine. In our situation, the board may well take an interest in that. And there's also the question of if you have other interested persons, the neighbors, for example, the complainants, the town, that is unhappy with the department's resolution of a matter through a civil citation, do they have an avenue? Do they have an avenue to go and ask someone, hey, the department said this was enough, we really don't think so. I think that should be in here as well. I couldn't tell you on the fly how to work that in, but.
And I think that, that's something that we would like, because when you say no, they call us.
Yeah.
And I think that's where a lot of this is coming, is trying to find a way to take off some of that lesser issues and help members of the public feel that they're heard and their concerns are heard and valid without having to spend $100,000 on an attorney. And that's a lot of money for a town.
I absolutely understand and agree. And there should be, there needs to be a better, simpler process that is more, addresses the need in a more expeditious fashion and in a way that does provide relief, because there are now many more thousands of people affected by these things than there used to be. So we need to recognize that.
Okay, well, I think I want to give everybody time to work this out, because I want to make sure that we do it as well as it can humanly be done in the next week. So,
Next 3
no,
days.
This is, I would like to get this out this year. I have a feeling if we don't get it out in the next week, something will come our way within a week or two. But I think I'd like to get it out of here, but do it as well as we can, so. I'm gonna do my famous, you should all go to the hall and talk and figure out a solution. And I'm gonna hear from the board, but I have a feeling they're gonna have some concerns too. The more you can work out together, probably the better for all.
So could I add in to communicate with Aaron? I know Aaron has sent you language and asked for input, but to make that happen, so that we can compare this. So is the dig safe process that you do now is a civil violation? And it's fair, which is what we had in originally. It's something that you're used to doing, but it doesn't fit apparently, it's a little too complex,
Well, it's,
and it doesn't fit with the board. I don't know. I'm trying to figure it out.
from our perspective, the dig safe process, it has not worked out 100% as hoped. And there are, that's a venue in which violations are pretty clear cut. The cable was cut or it wasn't. It's not like, well, how high are the trees? Are they the right caliper? Are they, you know, the million things that can come up under conditions of a CPG.
50 feet or 60 feet.
Yeah. So the feeling in our shop was that it was not entirely applicable. It was not really something we wanted to duplicate in the CPG area.
Okay, so can I make another suggestion? So, as you're reviewing S.52, the entire thing, there are places in the bill where there's notice to be given, and I know that this is, I don't know that we can deal with this right now, but I asked Aaron to identify places in the bill where there are different timelines. So 28 days in one place, 21 days in another place, 24 days perhaps in another place. So is there a way that we can make consistent the time for notice? And I know that there are other people in the room who may not like to hear that, but if they could all be 30 days or they could all be 28 days, then the average citizen would know that, you know, is it 21 or is it, you know, what is it?
It's a telecom.
Right.
Utility.
Yeah, so just a thought.
I just, there are other appeals to the board that have timelines. Existing for other violations. You know, same scholars.
Yeah. There might be organizations that would like to stick with what's there, you know, so.
There seem to be variations in communication and hearing times,
Yes.
depending on if it's poles and wires or telecom or, you know, and, or pipelines.
If I could make one comment on that, one of the difficulties for, and we hear this from citizens and we have this problem ourselves, is knowing when to start the period. Does it start when you get it in the mail? Does it start when it's filed with the board, except you don't know when it's filed with the board?
And that we
and
think
that's-
we've got addressed.
So
I was going to say.
that's
yes.
another one in sections 3 and 4. Is it when the copies are delivered, 2 days for delivery, or is it 2 days for sending copies? Please think about that too.
I think we've already been told, we know when we put it in the mail, but we have no idea when the mailman delivers it in rural Vermont, so.
I was wondering if we could make an attempt to hear from some sort of consumer, I don't know if it's the League of Cities and Towns, or have you heard from them, but especially on the enforcement piece, you know, I was on the DRB, these kind of complaints, even though they weren't in our purview, would get to us and these neighbors fighting or these kinds of things, and I want to make sure from, not just the department or the board's perspective, that the people on the ground who are filing these things find this process that we're putting forward
We can
acceptable.
send it over to the lead and probably our best source to get it out. We did hear from some neighbors who had issues last year, but we can just send the whole packet to the League of Cities and Towns.
I mean, I'm not trying to delay, I really like it, it's really good, but I don't think we've heard from the consumers really.
I would certainly support getting it out, getting comments from different people, different perspectives.
Short on time. Okay. Okay, are we over or under? A little over, okay, we'll move it. George, come on up. Anybody that is short on time, ever just raise your hand
Well,
and holler at me.
It's not clear.
Which I'm first.
It's not clear how short on time I am, since we have a public hearing in St. Johnsbury on the Fairpoint consolidated merger tonight.
Oh,
And so they're not going to leave without me. So if you keep me long, I mean, I try to encourage them to, but
local
Well,
public
nobody here-
hearings, they tar and feather you if you're late.
Nobody here
so-
represents St. J's, so I say we take our time.
Oh. No, I,
They'll still
like
wait
our
for me.
public servants,
That's right.
treat us well, local. Okay.
Okay, introduction, I'm George Young, Policy Director, Deputy General Counsel at the board. I'm also, for the present time, Acting General Counsel. So I've got a few little hats running around. I'm going to try to, I have some ideas that I want to get across in detail, but let me get through a couple little things. We were just talking about the difference between delivery versus service. The bill, especially if you look on page 4 right now of S.52, it refers to delivery.
Full version?
The full version, yes, I'm sorry. There's a reference, line 11, deliver copies, 16, date by which delivery. You have that built in there. We think that ought to be service, and I understand the concern that you don't know when something's going to get delivered, but that works both ways, because if you have a situation where somebody's an out-of-state property owner and is never there to receive the mail, does the time clock not start because they happen to be out of state? If somebody's on vacation for a week, does the clock? Service is sort of what's typically used in civil legal practice.
How would you say that?
I think what
Is it,
we can give you specific by which
it's not send copies.
the applicant shall serve copies on line 11.
Does that mean they have to take it out of state and hand it over?
Typically, under our rules, we require, for most things, we require certified mail being sent, but civil practice would say you drop it in the mailbox, it's presumed to be delivered, to be served within three days. I mean, that's how court practice tends to work, and that's the presumption built in there. And so that you have the obligation to effect service, but you can't control what's on the other end, on the receiving end of that.
They're on a cruise for 2 weeks and they're not getting mail.
And from our standpoint, it would create massive confusion. Delivery has the potential for massive confusion as to what the start date is. That's a technical item, and I know it was also just suggested, gee, what about the 21 days, the 28 days? Having been around for a few years, let me just say, those times did not come from us. And perhaps they originated with other people raising concerns over here, and the time periods were selected for various reasons, so that you have cell towers at 21 days, 248Js at 28 days. I think it's 28. So a lot of those time periods, I haven't talked to the board to see what they would prefer. They have some preference, I'm not sure we do, but if you're going to align them, I think the aligning at the upper end as opposed to the lower end would be our preference.
Longer time.
30 days,
Well, whichever.
whatever.
Part of the problem when you look at the time periods is that a lot of them serve different purposes. So in a 248J, it is actually the time period by which which comments are due. In a 248A, it's the time period for which comments are due. For other purposes in here, it triggers something else. So you have to look at exactly what's being triggered and what those time periods. But if you wanted to, I don't think we would have a problem if you align 248J and on net metering, you've taken care of the rule. If you align 248J and 248 A with no parentheses. But I think you'll hear from the people wanting to cite cell towers that they might have a different preference on that. So I'm going to duck taking a strong position on that, but those weren't I don't think those were our proposals, other than don't make them too short.
We may be part of that problem.
So on to other items. I haven't had a chance to, other than, looking at it quickly here, to review this bill in depth, the new version of the penalty provision. But I think I'm still fine, because I think I've looked at it enough to figure out some basic kind of. I want to step back before I get into details, though. And I think we ought to keep in mind that Section 30 and our penalty provisions related to Section 248 violations, 246, which is citing of Met Towers, 248A or 8010 net metering facilities are our rules. There's a wide range in there. You have the person who puts the hedge up and a bunch of the trees die, but you also have we have an ongoing violation where Vermont Gas is alleged to have destroyed a whole lot of endangered species, and what's the penalty amount for that? We have the when Entergy started constructing on a building for a generator rewind back in the mid-2000s, we imposed an $85,000 penalty because they didn't get our approval first. So you have small violations and you have big ones, and the statute covers the full range of those. You also have the situation, a bunch of the things we're dealing with now are some of the small net metering facilities or small generating facilities that they, for whatever reason, don't get our approval first. Now, those, it's tended to be fairly quick proceedings. We've issued penalties and small penalties, and they haven't taken that long. I think the ones that are bogging down are the ones that are bigger facilities that are being heavily litigated, and those are unlikely to be addressed by this legislation, because if somebody wants to avail themselves of all their rights, that's where we're going to be. In terms of, I do want to briefly touch on one issue raised about resources. In terms of resources, this isn't taking up a lot of board resources these days, except perhaps the more heavily litigated ones are. But the smaller ones, we generally get referred to the department. If we get a recommendation back, the penalties tend to happen fairly quick, and they really haven't taken a lot of resources. So I don't think if one enacted this statute that it would actually reduce our workload much at all. Frankly, if the department was aggressive and did a lot of it, it actually might increase our workload as people appeal their violations. On the other hand, you're accomplishing a result, so it's not like, I'm not here to complain about the outcome if you're getting better compliance at the other end. So, getting into a couple of things, we had floated a proposal, an alternative proposal a week ago. I did a revised version that I think Kevin sent over to you earlier today, and we actually had two alternatives. I'm not going to talk about those a lot. I mean, there's a simplification that we tried to go through there as opposed to developing a really detailed process. And the reason we did that is to address the one thing that I do want to focus on in here. And it really comes down to something that Jeff talked about a little bit, and that's the finality of the decision where the applicant does not, or where the alleged violator does not contest it to the board. And that's, to us, that creates a real problem, because you have a situation where we wrote the CPG, Certificate of Public Good. We wrote the order. Here's the condition. The department then seeks to enforce it. The violator says, here's your $500 check. Here's your $1,000 check. And the board has no say in whether that's a reasonable outcome for that violation of a condition that we opposed. Conceivably, it could even be a condition that the department didn't want in the first place. But we're done. We have no public process. We could have adjoining landowners who are upset about it. There's nothing that we can't take comments from them, which we typically would. I mean, it's not like we invite adjoining landowners. If they have an interest, they are permitted to intervene in the proceedings. But the finality in that case simply creates a problem. It also, especially in the instance where you have this preservation of authority over continuing violations, creates an ambiguity in what is a continuing violation in that sense, where the department has agreed that if they change the plantings in this way, or if they do something as part of the remediation, well, if it conflicts with the board order, you probably have to amend the board order, in which case we can enforce, because you haven't. You create dual enforcement unintentionally over the same thing, and I think it creates a lot of confusion. And that's why in the longer version of the piece that we had distributed, we had a different paragraph in there. I think it was paragraph 4 that we would put in place of the paragraph 4.
Which is paragraph 4?
Well, you had, I'm sorry, Senator, on page 3 you have a paragraph 4 starting on line 11,
Okay, thanks.
which is basically the conclusion. If they pay, everything's done, and the board has no role, and the department has no further role. And I think when we sent around a draft earlier, we had included an alternative paragraph that would have preserved the board authority to seek a subsequent penalty for the same actions.
And that's this proposal.
That's correct.
Okay.
And I think you don't need to go through all of that, because the first part of it is, you know, it's just different wording from what Aaron's done for you here. I don't think, again, I've had limited time to look at this, but it's not all that different conceptually from what his option 3 had been. The big thing is sort of the preservation of the board's authority, that if you're going to go through this fast approach and the violator, alleged violator, may settle on that, the board either needs a role then, or it needs the ability to do enforcement later on, which could include the opportunity for an adjoining landowner to request a hearing, because, and frankly, we're getting a number of those in these small complaints.
So if the department does the civil fine because the hedge is only 3 feet tall, and the guy says, yeah, I'll pay $500 or $1,000, cheaper than putting up bigger trees. And then the neighbor complains again and says, he went out and poured some fertilizer on them, it's polluting my stream, and they're still only 3.5 feet tall, and they aren't going to grow any taller because that's the kind of plant they are. So there's another hearing, and this time there's a $2,000 fine. He says, no, he'll do it. So it gets the third hearing. You've been left out of this, but you have someone who sounds like is just has no intention of doing what they agreed to do before you. You've been left out of everything up until you get a third complaint from the town, and then it lands, you know, they request a hearing before you, or? I mean, is is it that a lot can go on, you issue the order, a lot can go on with minor violations that you have no part in until it reaches a critical mass where it gets dumped back on you.
It's not just that we have no, you know, we have no ability to initiate something. Well, I guess we could initiate something on our own. The department issues a notice of violation, we say, oh, that looks interesting, we're just going to open our own investigation, in which case the whole process gets moved into that area. But if the department, I mean, the concern is if the department reaches an arrangement with an alleged violator, and believe me, I don't want to in any way say that they're doing it wrong. It's just as a matter of, sometimes they view things differently than the board. And we certainly see that in penalty cases where their recommended penalties are very different from what we ultimately order. The concern is that there is no role for the board in the situation you're talking about where they agree to a penalty for plantings but no remediation action. Conceivably, that would fall into your continuing violation, and unless they ask for an amendment of the certificate of public good, they're immediately in violation the next day, which is going to certainly surprise them. Because they paid and they thought they had reached an arrangement. I've been around Jeff for a long time. The department's got good lawyers over there. They're likely to wrap it up in a way that is going to try to help ensure that the person's not right back in court the next day by telling them, oh, you have to go get your certificate of public good. They know what to do, but you have this situation where we may have intended something in our orders and our conditions that we get no say in the ultimate enforcement. Let me just say, we're not looking to jump up and do enforcement unnecessarily. The idea of the department having a stronger role of getting this started is a real positive because we don't have enforcement resources internally, and this is a very constructive direction that people are going in. But our concern is if there's a settlement, the absence of a role for us, for the public, for anybody else who, adjoining landowners who might be affected. And I think that's our primary area of concern. Let me just touch on a couple of other things. I haven't had a chance, obviously, to talk to the board members about how they feel about the MOU provisions with A&R. Offhand, I would say we probably wouldn't have a great problem with them, but I would also point out the nature of violations that we've had to date, other than the Vermont gas and the harsh sunflower case, which I don't want to get into the merits of because it's pending. But other than that, most of them tend to be issues that are really not A&R issues. They're going to be visual, aesthetics. Everybody seems to focus on the tree plantings for screening, and are rarely testifies on those issues. A number of them are construction without a certificate of public good in advance. Again, that's straight our jurisdiction more than anything else.
Are the ones without a permit, are these folks that put a net metering panel in their backyard and or on their roof and they don't know that if I'm putting a couple panels on my roof and net metering, I need a permit?
There are a couple of those. I don't think.
I didn't know that we needed a permit. I would think that I would need a permit to put a couple solar panels on my roof.
And typically for small ones, we're not spending our time sending out sanctions on them. Where we've sent out sanctions for smaller net metering facilities, my prime example is one where the application basically said things that were incorrect, and then they went ahead and built it in a place. They said it wasn't visible from a neighbor, and it happened to be like right in the person's front window. We thought that probably was severe enough to warrant a sanction. Again, misrepresentation in the application and the construction without. But we're not spending our time with individual landowners. I mean, we have issued penalties. I can think of one up in the Northeast Kingdom where someone constructed the panels without prior board approval. It wasn't small. It was like 30 or 40 kilowatts. I mean, it might have been even bigger. And I think the sanction was relatively small, $500 to $1,000. It's not, where people truly don't know, I mean, if you're a developer who's building a 500 kW facility, we're probably not going to believe that you didn't know part.
You should have.
But we are aware of what real people are. But in terms of so I'm not going to say that there's a problem with trying to work out with A&R, but it's most of the violations that we've seen, or the alleged violations that we've seen, it's not going to make much of a difference, because if they're on issues that they typically don't get into. Or, again, I'll just use the harsh sunflower that Vermont Gas, when A&R issued its own penalties for their violations of statutes under its jurisdiction, we still have a pending case going on penalties because they violated conditions in our certificate of public good. For obvious reasons, I can't talk about what we're doing with that or where the penalties might be. But there's parallel jurisdiction with A&R on a lot of these things. Or if somebody constructed in wetlands, you might violate both their requirements and our requirements. And maybe there are places where you could derive synergies for enforcement in that type of area. But that's not.
Yeah, it would seem like they would be better qualified to determine if this is a wetlands than perhaps you, but you are.
We would prefer to let them determine it rather than us
We
trying to
don't
go
want to
out.
go out with the blueberries and the skunk cabbage and all that good stuff.
Part of what we're trying to do, correct me if I'm wrong, is really hold some kind of public service board responsible when it's not acting, correct? I'm just thinking about, go ahead.
I don't know that we've heard that they're not acting. I think it's the frustration, it's a court, and a
Right, so I'm
court
thinking-
moves
right.
at its own pace, whereas the public who is looking at what they think is an ugly thing or the potential of an ugly thing.
Or in the case, I know we've heard from people with wind, noise, and we had somebody here at some point feeling there was not action. People have not acted. So who then comes in and says, you've not acted, we've filed X, Y, and Z, time to get going and actually act. And I'm wondering, Senator Lynn.
And so, well, and when you look at the draft proposal for enforcement, and the section that allows for the board to enter into an MOU with the A&R Enforcement Division, the conditions could be written within the MOU that might facilitate some of the things that Senator Campion is talking about. And so there are different ways of looking at that MOU.
You certainly could do something like that. I will say, again, sound tends to be an issue that A&R has not actively participated in our proceedings. The department
I wasn't necessarily meaning
Right.
sound, wetlands or something else. Endangered species.
Fair enough. And I will acknowledge that we have not been as fast dealing with sound complaints as neighbors would like.
Right.
Let me just say.
I'm thinking of the one house that I visited last year, or maybe it was the year before now. Right. A family up in Georgia Mountain. Right.
Which is an ongoing issue,
Yeah.
and I can honestly say I have reviewed orders, 4 or 5 orders in the last month, just trying to deal with the continual issues. I mean, this is what you get in a legal process. At some point where the other side wants to lawyer up and spend a lot of resources, and I'm not saying that's wrong, but there are a lot of heavily litigated issues going in there. And I'm hearing officer on the Sound Complaint Association of Sheffield and the Brujas, and we just spent 2 days of hearings hearing testimony on how you design a sound monitoring. A lot of these things, the hedgerows are pretty easy.
Right.
Some of these others, we're out in places where it's not necessarily as easy to figure out.
No, I understand. That's one of the reasons we.
Now, having dealt
In
with
your
the
hands and not-
nightclub and sound and finding out it's vibration, not something that registers on a decibel meter, and how do you, but people's innards were they were vibrating at 2 in the morning, and
I was not there,
It's
I don't
very it's very difficult to figure it out. That really bothered the neighbors.
And I, having visited these folks, I get it. It's something that I want to get some resolution on. I know we passed, it's not a committee thing. I mean, because of its complexity, I think it's.
Let me just.
I don't want to get excited.
On the same line, I mean, if it's a really tough process for the board or the department to figure out, why wouldn't we slow down and figure it out before we keep going forward with these projects?
I think we're in the process of doing a sound rule at the direction of the legislature that's intended to try to provide greater clarity to that. But we also have to, at some point, make sure we have the right monitoring systems in place.
Sure.
And
we're happy doing that. So why wouldn't we say, until we get these things in process, we're not going to continue with these projects?
I think that's a choice you can make. I think this is an area where I really can't speak for the board about.
And I think we're getting a little off topic.
I think these are the choices for you to make and tell us what you want, and if you think that's. This is an area where we have conditions out there. We thought, based upon the evidence, that the conditions on sound were enforceable and would make sense. And then when you start getting complaints, you discover all the ambiguities and what you thought you knew. And I have learned more about certain sound monitoring than I thought I would ever have to at the Public Service Board. I like getting into technical issues, but this is not one that I expected to ever have to.
Yeah, no,
This is complicated. We're working on it. We're getting through it. I think.
is timing?
Well, the sound rule, I think we're required to have it out by the end of June. Is that right, Kevin?
We have to adopt the final rule by July 1.
So we'll see before.
Expect, we should have sometime in the next
But this is
month, let's say.
getting off topic,
Yeah.
way off topic.
No, I
Hey,
appreciate
this
it.
is another topic.
It's getting off topic, but again, this
It
is.
does relate to a lot
Yes, it
of what we're
does.
talking about, the testimony we heard from folks early on.
And it also relates to, you don't know what the size of the penalties. I mean, you could have in a sound complaint, the department determining for valid reasons on their part that $3,000, $5,000 is the appropriate sanction, and the board sitting there saying, oh my God, they paid it, we can't do anything, we think this ought to be more. So, I mean, this is the type of trade-off we might, and it's not that they're right or we're right, but, it's different, and our certificate of public good, and as I said, we do different things. One other point I did want to make, the 3,000 versus 5,000, when we prepared our draft version, we put in the 5,000 also. If you're going to empower the department, I mean, again, we have the ability to go up to 100,000 or 100% of the gross operating revenues, which was higher, for violations. But empowering the department above 3,000 is probably a good thing from our standpoint.
Okay, I said the same thing.
And I'm happy to take any other questions, comments.
It's very helpful, thank you.
Thank you. Anything you can do to kind of work this out amongst yourselves would, I think, be helpful for us.
This is good news, I
I
hope.
think personally, this is above my pay grade. It gets really in to how the two departments, organizations work together. I think we like, the whole thing with A&R was that they didn't want to have to duplicate and stay of efficiency a whole investigative system. But, and the testimony we had said, well, most of the violations would be A&R related anyway. But you're saying not necessarily.
That's not what we're seeing, and A&R may have the structure in place to do enforcement. They may not be geared up to do the type of enforcement that we're talking about. about here. And, you know, to the extent, we'll be happy to work with the department, we're happy to work with Aaron trying to craft something. In coming up with the proposals that I floated, I did talk to Margaret Cheney, who was in the Act 170 working group with Senator Lyons a fair bit, and those were developed in conjunction with her, or at least the longer one. The shorter one was an attempt to just sort of simplify, rather than developing this whole big enforcement mechanism. But I will acknowledge it doesn't really give the department the power that some of the others do. And trying to balance that is difficult because, but we're certainly happy to work with others on this.
I think that would be good. I think we're trying to just get a little more speed and let you deal with the bigger issues.
And I do think most of the small ones we're getting out fast. It's the problem is, you know, as the senator was just mentioning, you know, if you're hearing sound, it doesn't matter whether you consider it big or little. You don't want to hear the sound, and
You're not sleeping.
offensive sound. So it doesn't matter that you know, your primary concern is not that we're having to deal with the litigation over the sound.
Right. Okay, Margaret.
So I appreciate your comments about wanting to retain some involvement on issues that the board finds important. But when you work with the other people, you also try and find the sweet spot where there's some finality to these small cases, so the violator knows that thing was done. So like within 30 days, you have to come with some sort of objection or just some balance there. Because I don't think we want things open-ended. We're trying to bring some streamlining here.
I actually appreciate that comment. That's something we hadn't built in anything we've written, but that I find that very constructive, and we will talk about that.
Thank you. The same answer.
Thank you very much. Thank you.
Address any specific questions you have about how we undertake our enforcement at A&R right now, and how that may or may not be a good model for what you're looking at in this. So first off, we certainly support the idea of improved investigation and enforcement for certificate of public goods. I think without enforcement, those permits are not, there's just enhanced risk for violation, and the public interest is not being served. Given the pace and scope of energy development in the state, it's really critical that there is a good enforcement mechanism. And the takeaways from what I've heard so far today are really that there needs to be a clear investigation process. So the public knows who to speak to when they have concern. They know their complaints are being addressed in a timely fashion, and there's some time frame for when they know that there's going to be a response. And I know that the Department of Public Service is already working to improve their response to complaints. We've been supporting that activity, and it sounds like there's a willingness to continue doing so. And I think later today, we and the board and the department can pick some ideas around and come back to you with some suggestions. Second, it sounds like there's a real interest in having an expedited path for simple violations that can be resolved through some sort of simple standard fine. I would caution that there probably are less straightforward violations than you might suspect. Even things like landscape plantings are not as straightforward as you might hope. But I think that does make sense to have a more stripped down, pared down version to resolve those in an expedited way, and I think we could come up with some suggestions. Critically, I think there needs to remain a more robust process for more significant violations. I think you heard the board express that there are some violations that have penalties in the tens of thousands of dollars that have the potential to impact significant natural resources or other public interests. And that process needs to be driven by the board or the department, and not something that an applicant can opt out of if they're willing to just pay a fine. There needs to be opportunities for other parties to participate in that, and I think that ultimately the board is the right decision maker. As discussed, they do issue these permits. Their orders often build off of each other, so they need to establish and maintain a relationship with their regulated community, and making decisions about enforcement is a critical way to do that. So with that said, I think we would be certainly willing to work with the board and the department to help come up with a process that does those things. Quick and clear response to complaints, an expedited path for simple violations, and then a more clear and predictable process for the more complicated ones. I think we've learned a lot of lessons in the years that we've done enforcement through the DEC, and I think maybe Kim, you could just give an overview of how we do the work that we do and what lessons may be relevant.
Thanks again, Kim Greenwood, Director of the Environmental Compliance Division for DEC. We have learned a lot over the years, and we've learned a lot in partnering, especially with the Agency of Agriculture, where we, some of the language that I've seen mimics that process, and I think there's a lot of lessons that we've learned from that indicate to me that may not be a system you would be interested in replicating. We're working diligently to make improvements there, but the way that I look at the decision in front of you right now is that you have an opportunity to take what we've learned and set up a process that works from the beginning. And by enabling the board and the department to have the mechanisms in place that enable quick, responsive, effective enforcement, that an MOU may actually drag down counter to what you're trying to produce. And we would be happy to offer what we've learned as a result of that process to help kind of set the department and the board up to pick up where we are now and really launch a much better enforcement program.
I think we're doing a lot of work for some of the violations of the CPG. But I think the heavier testimony we've heard is the CPG process in and of itself, which is expensive, technical, requires expertise, but it is a complicated process. And I think so we've got two levels to work on. And if all we do is just MOU or no MOU, and we're going to do a couple of speeded up violations, that's not going to solve the problem. So I think as we go out and we think, is there a way we could, the environmental court, I haven't heard the same complaints, but I don't know if it's the same degree of technicality that utilities are.
They are judges
They are judges.
versus three political appointees.
True. All right.
The three political appointees being,
Public service member. By the governor.
But they serve long terms.
so the judge process isn't it somewhat going forward?
Okay, we're not getting into judicial nominations and retentions. And I will remind you that the Taste of Vermont is in the cafeteria, and you are standing between yourself and a lot of cheese. So,
I don't know about the rest of you, but some degree and I are here to do the people's work.
That's
So
what I was thinking.
take as long as you'd like.
About
okay.
to roll up my sleeve.
I guess just quickly, all I'd offer on that is that I think a much smaller number of cases ultimately get to the environmental court. I think the frustration that many people feel is that the Public Service Board, because of the success the state has had in distributed generation, just sees many, many more projects. So more Vermonters have had experience with that. And when a case eventually gets to the environmental court, typically at that point, you have a decision that's already come down, you have attorneys, you're at the point where you're engaging at a fairly sophisticated level, so maybe you're not hearing the same complaints with that process. And I do know that at least with the board's new net metering rule, there have been improvements, at least from our agency's perspective, in the requirements for the application, requiring clear site plans, a better articulation of where and what the project is in the first instance. So hopefully neighbors and other concerned citizens will have more information to work with right off the bat than we have in the past. That rule is just being implemented now, so it remains to be seen. But we had similar frustrations. We wouldn't have the information we needed to engage fully in a net metering proceeding because of some of the quality of the applications.
Okay, so that's the first we've heard of that, so that might be helpful if the new rule requires, and maybe we'll have someone come talk to us about the new rule. We have in the past, but not at that level.
Yeah.
Just a general overview of the new landscape of net metering, which is, there's a lot more of it than we envisioned maybe 10 years ago when we started. So that may be something. Thank you for letting us look there, because I think if we could get more information from the developer up front, it would help the neighbors.
And so, if you look at the recommendations that accompany the legislation, you'll find that there's more opportunity for pre-hearing conferences with the public, so that the public is better informed. I think we probably should look at that and determine how much, if we can have a more powerful statement about implementing the recommendations.
I think we can, I'm starting to feel in overload, but.
At least it was all the same subject.
Yes.
It wasn't the mental gymnastics you put through Thursday.
You did not have mental gymnastics.
Trying to play my
Okay.
ADHD.
We will be continuing on this. Something tells me we're not going to spill out by Friday.
I think we will. We're going to have this. But we've asked to have language back so that we can.
Yeah, I think on the
I'm
enforcement,
not going to give up on that.
I think we will get it out, but I think this is admittedly the low-hanging fruit that we're dealing with at this point. I mean, it's not,
Well, I mean,
it's not up at the full,
the way I feel
full-blown
is that
$80,000 lawyer hearing.
the Public Service Board, for whatever reason, it wasn't set up for this volume of citizen interaction. It has become out of reach. I don't think this bill
It's
is
become what?
out of reach for your average citizen. I don't think Act 250 is that way. Like Act 250 is very, very within reach.
So this is exactly why the recommendations that you have in front of you include procedural changes to the board that would bring those Act 250 processes into the board and make it a friendlier environment for citizens.
And we'll go back over those, because we've got stuck on the enforcement sections
Yeah.
and been dealing with those out of context. And we have a bill, and then we have recommendations, so we're dealing in 3 different layers of paper here. And I think it's putting it all back together.
One of the things Senate Natural Resource and Energy did, and you and others might find interesting, we went over to the Public Service Board. One of the things that was interesting for me is the thousands of cases that they actually hear. I mean, the controversial ones are, but it is an interesting process to go over and just sit with them.
How long is our field trip?
I think it counted actually as one of there are. Yeah, I know.
So we're supposed to take a field trip per month, right?
I'm not sure.
Yeah, I haven't got any.
But it actually, you might find, it would be interesting.
Okay.
I was shocked by the number.
Yeah.
So
They want to be interrogated.
If they choose.
Yeah, certainly.
So in the your comments about having an MOU, you're suggesting that an MOU might be too cumbersome?
Might
So
slow
what would
down.
you suggest? How could the Agency of Natural Resources Enforcement Division be helpful to the enforcement process at the board and through the department?
I think enforcement is largely a matter of culture and process and having both of those pieces in place. So that when a violation is identified, there's a clear path for how it moves and everybody has a role and there are people to perform those roles. And if those things aren't in place, enforcement is very messy and doesn't happen very well, both for the public and for the resources. So to answer your question, having the agency, our agency, assist in kind of share what we've learned in terms of setting up that process would be a better way than trying to align 2 different cultures with different priorities, which then, as we've seen with agriculture, can vastly and dramatically slow down the movement of those cases. Whereas when we look at our enforcement cases, which are not perfect, but things move pretty smoothly and clearly through a process that when you're moving across departments or agencies, instantly slows down the process, and I would argue slows down the effectiveness.
So good, and that really also is an expression of what we learned about the Act 250 process. That it's a different culture, but there are some lessons to be learned that Public Service Board can gain in their process.
Okay.
That's helpful, thank you.
Thank you, and thank everybody. I hope you can get some work offline. And with these kinds of hearings in this new world where there's just so many more and so much more impact, how do we move us forward? Okay. Yes.